States. The older regulation said that from the items of income listed in preceding sections, which constitute income from sources within the United States, there shall, in the case of non-resident aliens and foreign corporations doing business within the United States, be deducted allowable deductions, and the remainder was to be included in full as net income from sources within the United States. The section also included an example showing how a non-resident alien would compute his taxable income. When this section became Section 1.861-8, most of it remained the same. However, the phrase saying exactly who it was about simply vanished. It now said that from the items described in preceding sections, which constitute income from sources within the United States, certain deductions were to be subtracted, and the remainder was to be included in full as taxable income from sources within the United States. It no longer admitted to whom it actually applied. In addition, the example used in the section was identical to the example in the older regulations, except that instead of referring to a non-resident alien doing business in the United States, it simply referred to a taxpayer. All the numbers stayed the same, but the wording was changed in a way that would seem to imply that the domestic income of everyone is taxable. Again, Congress specifically said that the legal application of this section had not changed significantly. So why were these regulations changed? An equally conspicuous change occurred in the section regarding interest from the United States. The older regulations clearly said that interest from the United States was to be included in the gross income of non-resident aliens, foreign corporations, and those who receive most of their income from federal possessions. After 1954, the text of the regulation remained exactly the same, word for word, except for the phrase saying who must include domestic interest as gross income, which simply disappeared from the section. Now the section seemed to say that interest from the U.S. always constituted taxable gross income. Since the correct application of the law did not change, this rewording can only be explained by a premeditated attempt to mislead the reader. It is undeniable that Section 217 in 1925 only said that domestic income was taxable for non-resident aliens, foreign corporations, and United States individuals and corporations who also received income from federal possessions. Since the correct application of this section has not changed since then, what purpose was served by all the subsequent changes to the wording of the statutes and regulations, except to hide the truth about who could actually have taxable income from sources within the United States? To review, here is what the law told us in 1939. The statute defining gross income gave a broadly worded general definition, but the related regulations showed that some income not exempted by any statute was nonetheless excluded by the Constitution itself. The regulations then specifically listed those types of commerce which were not exempt: certain foreign income of Americans, the domestic income of foreigners, and the domestic income of Americans who also had possessions income. In addition, the statute defining gross income said that for computing gross income from sources within and without the United States, one should refer to Section 119, the predecessor of Section 861 and following. This was a clear, direct link between the general definition of gross income and the specific rules about income from sources within and without the United States. Back in 1939, Section 119 of the statutes gave rules about the geographical origin of income, describing how to determine whether income was to be considered as coming from inside of or outside of the United States. The related regulations then specifically and repeatedly described those situations in which income from within the United States was taxable, namely for foreigners and for Americans who also had income from federal possessions. This matches exactly what the 1925 statute showed as well. Note that in 1939, the regulations generally defining gross income and the specific rules about income from within the United States both said that domestic income was taxable for foreigners and for Americans who also received possessions income. After 1954, the statute still gave a broadly worded general definition of gross income, but the related regulations no longer mention the Constitution, nor did they mention the specific types of commerce, income from which was taxable. In addition, the link to what is now Section 861 was removed from the statutes. It exists now only in the form of the cross-references under Section 61 put in by the printers of the code. In addition, after 1954, the rules about income from within and without still gave rules about the geographical origin of income, but the regulations no longer mentioned that income from the U.S. was only taxable for those involved in specific activities. In both the statutes and regulations, the truth had been purged from the law books, even though Congress said the application of these sections had not changed. Only later did the truth return to the regulations under Section 861, which is now the only place the truth is found, both the truth about which income is exempt and the truth about which income from within the United States is taxable. But just after 1954, the truth was virtually impossible to find, unless the reader was aware of the history of the sections and the scope and purpose of Subchapter N. The title of Section 1.861-8 was then Computation of Taxable Income from Sources Within the United States. It seemed an obvious place for people to look to determine their taxable domestic income, but if the average American did look there, he would most likely incorrectly conclude that his income was taxable. In 1978, this title was expanded to read Computation of Taxable Income from Sources Within the United States and from Other Sources and Activities. Based on that title, some now claim that one should only refer to this section if he has both domestic and foreign income, though numerous citations prove that to be incorrect. In addition to the title change, the text of the section went from less than 1 page to over 30 pages, with no significant change in the statutes to justify it. Along with the explosion in the size of the section, a host of new legalese phrases appeared, including specific sources, operative sections, statutory groupings, etc. In the midst of this new maze, the list of taxable activities was inserted under the inconspicuous heading Miscellaneous Matters. But again, aside from various new rules about foreign tax credits and international sales corporations, the list is about foreigners and those who receive income from federal possessions. Anyone struggling through the 30-some pages of the current 1.861-8 and comparing it to the older regulations would be hard-pressed to find any honest motive for these changes. They certainly don't clarify anything, and there was no change in the statutes making such an expansion necessary. Instead, the change seemed designed to confuse the reader. Later, in 1988, the title of Part 1 of Subchapter N, as it appears in the Government Printing Office version of the code, was changed from Determination of Sources of Income to Source Rules and Other General Rules Relating to Foreign Income. The text of these sections had not significantly changed, and the law says that titles of parts carry no legal weight, so why change the title? Again, coming up with an honest explanation is difficult, but a deceptive motive is readily apparent when we examine the table of contents of the law before and after this change. Because gross income is generally defined as all income from whatever source derived, the table of contents prior to 1988 laid out a fairly obvious path to Section 861. Subchapter N was about tax based on income from sources within or without the United States, Part 1 was about determination of source